Mhm.
Court calls the case People versus Tony Bailey. 2 cases.
Alexander on behalf of the people.
Okay, this poor guy. He's in the middle in orange. I did a video on him recently where he showed Judge a picture of a hot rod that he made for him. I don't know. He's kind of charming, and watching Judge Simpson deal with him is charming.
And good morning, Your Honor. Gina Noveski, First Assistant Public Defender, with and on behalf of Mr. Bailey, who is present from the jail.
Good morning.
Bailey, state your name.
Tony Warren Bailey. Good morning, Judge Shelton.
Hey, well, that's okay. That's close. Good morning.
Good morning. Good morning. Good morning. Today is my
Good
daughter's birthday. She's turned 32 today. Good morning.
All right.
Remember
Good
these piranhas, Your Honor? I brought you a picture of them.
No, I don't, but they look familiar. They look like the other piranhas I'm used to seeing.
Yeah, there are 7 of them that's floating in the tank right now that I got to go home and bury.
Okay. All right. Well, let's
Can I say
see what we can do.
Can I say one more thing, Judge Shelton?
I haven't been able to stop you yet. Go ahead.
Well, I've been here 90 days, Your Honor, and I completed all those other cases. I got them all squashed. Like I say, today is her birthday, and I did add a couple more things to your hot rod if you'd like to see it. The car I drew you last time, there's no bullets on it.
Okay. Okay, well, first of all, let's find out what we're doing on your case. Mr.
Okay,
Noveski.
thank you. Thank you.
Your Honor,
How you doing?
hi, Mr. Bailey.
Yes, that was very, very sweet of Meg. I can't watch it. I told Meg that. I've been messaging her. I can't watch it. It's too embarrassing. But I know she's sweet. I know she is.
Your Honor, I think what we need to do is set his matters for a preliminary exam.
All right. Then here's what I'll do. Preliminary examination will be set in person September 5th on both cases, 2023, 9 a.m. before Judge Washington.
Oh, that ought to be fun in front of Judge Washington. I want to see that dynamic play out.
This isn't horrible.
Your Honor, Mr. Bailey is hoping that I address bond.
Go for it.
Thank you very much, Your Honor. Mr. Bailey has been in for 90 days, Judge. I'm sure the court's aware that there was a referral previously, but he is asking that you would allow him to be released on a personal bond at this time, especially given the amount of time he's been in. As he indicated, today is his daughter's birthday. He would very much like to be out so that he can be with his family. Unfortunately, I believe his Social Security was terminated given the amount of time that he has spent in custody. So he's going to need to get that taken care of once he is out, and perhaps, we'll be able to provide him some assistance with that through our social work department. The court's already heard that he does have his piranhas at home that need to be addressed, as well as other matters in his home regarding his utilities.
I think the piranhas are taken care of. I mean, I don't think anything else needs to be done except maybe flush the toilet.
So he would very much ask you to allow him to be released.
Any response?
Your Honor, at this time, we would ask that his bond remain the same until his
Yes, those piranhas are pining for the fjord.
preliminary exam. Just given the nature of this case and how it's been going, we would just ask that the bond remain the same.
Oh, look who's here. Hi, Debbie.
I don't see how that's possible when I've been here 90 days. All my cases are.
How's his, is he in touch with CMH at all?
Yes, I am.
Okay, hold on, sir.
He's
Mr. Besky, do
indicating
you
yes,
know?
Judge. Just from what he just indicated, Judge.
Okay, here's what I'm going to do at this juncture. I'll allow it to be brought up certainly before Judge Washington at the preliminary examination, but I'm not going to change the bond at this time until information is provided regarding his contact with CMH. So at this time, bond will continue. Motion for bond reduction at this time is denied, but you can bring it up certainly before Judge Washington. Thank you.
Yeah,
Thank
good
you, Your
luck.
Honor. He's hoping to show you his picture today.
Okay. What picture, sir?
So, Your Honor, so you saying that I can't be
I just love Judge Simpson's. Okay.
released on tether or anything?
No, what I am indicating is,
I don't
that-
understand this. I mean, I've
Okay,
been
just
here-
listen.
I
Just
don't,
listen.
I'm okay. I'm listening, Your Honor. I've been here 90 days. All my cases.
no, I know. And what I'm trying to, you got to listen to me. If you're not going to listen to me, I'm done.
Okay, I'm gonna listen.
What I'm indicating is I'm not opposed to releasing you. It's just I need more information about your contact and connection with community mental health.
Mental health.
And that can either be brought to me or it can be brought to Judge Washington for our consideration.
I am confused right now. I only see mental health people here in the jailhouse. They bring me pictures of Ari. That's it. I don't have a connection. Can I explain it? I don't see mental health.
Look at Judge Simpson struggling. I enjoy it too much. I just enjoy it too much.
I have been cleared through mental health department that I am evident to stand a trial. I don't understand this part about me being slow or anything, or being retarded or anything. I don't have that problem.
Sir, that's not what I'm saying. What I'm saying is I need more information before I'm going to reduce your bond. That's the bottom line.
Mental health department through the jail? Is that what you're saying?
I've indicated it to your attorney. They'll work with you. I think they understand what I'm looking for. And so they'll talk to you about that. Okay?
Thank you, Your Honor.
Thank you.
Your Honor.
Holy wow. That's messed up.
Mr. Dean, good morning. Mr. Dean, you're here for first appearance. You've been accused of one count of loitering or prowling. Mr. Dean, there is probable cause for this charge. I'm going to appoint the public defender's office to represent you, and I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, at this point in time, I spoke to Mr. Dean, and he just, he is not going to plead anything. He's just going to ask for some kind of bond.
Yeah, I actually, Your Honor, excuse me, guys. I want to request a speedy trial be, motion for a speedy trial being in the court today. So I got 60 days from now to have a trial date set for that loitering charge.
Yeah, that's not correct. I'm not sure where you got your law degree at, but it's 90 days in Florida when you file the motion for speedy trial, not 60 days.
What is this accent that this defendant has going on? Is that Louisiana? What is that?
That
must be the
misdemeanor case,
misdemeanor,
but
like
Mr. Dean, I'm just going to set you a bond today, and we'll see you long before 90 days. Because you've been to prison 2 or 3 times. 3 times you've been to Department of Corrections. Your bond's going to be $5,000 cash or surety. Your bond has a condition, no contact with the property you're at. If you post the bond, we'll see you at a later court date out of custody. If you don't post the bond, we're going to see you in 3 or 4 weeks at a court date, well within your speedy trial time period. Any other questions, Mr. Dean?
You said I got a $5,000 bond for loitering charge, Your Honor?
Yes, sir. Yes, sir. Yes, sir. Any other
All right.
questions?
Yes, sir. So you got it on, you got it in the court transcript, right? Righteous that I request a speedy trial during the first appearance, correct?
It's on the record.
And you
that
stated it's 90 days?
Speedy trial in a misdemeanor case in Florida is 90 days.
Oh, okay. Like I told you, I wasn't familiar with misdemeanor case. I just knew felonies is 60 days, though. But all right.
Have a good day, sir.
I get on the
Run along.
Court calls the case. People versus Shauna Webb.
Name is Ganatra for the people.
Good afternoon, Your Honor.
Raymond Burkett on behalf of Ms. Webb.
You know how there's no crying in court, at least on Law Talk with Mike? Well, we've got a rule breaker here.
Ms. Webb, can you please?
Hi, Miss Webb here.
Okay, what are we doing?
Your Honor, Ms. Webb understands that she has a statutory right to a preliminary examination. I've discussed this with Mr. Conatra yesterday, and we asking this honorable court to allow her to waive her preliminary examination with the understanding that she's going to be bound over to the circuit court.
Yeah, there's an active bench warrant. You understand your client has a bench warrant for a failure to report or
Yes,
to
I
test
do,
at
Your
community
Honor.
corrections?
I do, Your Honor. Mr. Conatra called me last night and sent a copy over to that there was a bench warrant. However, Your Honor, then I emailed this honorable court as well as Mr. Conatra that shows that she have a case.
testing.
Beg your pardon?
Yeah, that she's been testing elsewhere.
Yes, Your Honor. And on the dates that she missed here, she had tested at the other place. And I'd ask you to dismiss the warrant. Also, she can't afford to be paying both of these people what she's doing to allow her to continue to the testing.
Well, cancel the bench warrant. Defendant has to arrange to have test results sent to community corrections.
Not a problem.
Not till she starts talking.
Ma'am, Ms. Webb,
Yes, I'm sorry.
you understand that you're waiving your right to a preliminary examination?
I don't understand what that means exactly.
Well played, Maggie.
Okay, a preliminary examination is a proceeding where the people would have to show by a standard of probable cause that the offenses alleged were committed and that you committed them. You understand that?
So does
All
that
right.
mean it's
You
pleading
would
guilty?
be entitled to have a hearing to show that there's probable cause that you should stand trial on these offenses. You understand that, man?
Yes.
He's like, woman, I told you this. I told you all this before we started this thing 30 seconds ago. It's not a big deal. It's just the frustration's funny.
I understand what that means now.
Okay. And you understand that at that hearing, the people would have to show by what the standard, the low standard of probable cause, that two things. First, that the offenses were committed and that you committed them. You understand that that's what will be happening at that hearing?
Yes,
Okay.
but I don't.
Your
agree.
counsel has indicated that you're waiving that hearing. And so you'll not have that hearing and that you'll proceed to circuit court to further resolve this case. You understand that, ma'am? That's what your attorney has said to us.
So I'm taking it to trial.
Well, you're going to circuit court to try to resolve the matter.
Okay.
You understand that?
Yeah.
Okay. Okay. Ms. Webb?
Yeah, I'm sorry. I'm just overwhelmed.
All right. Ms. Webb, is that what you want to do? Or you want me to adjourn it out so you can talk with your attorney a little bit more about what you should do?
I need to talk to him.
Okay. Here's what I'm going to do, Ms. Webb. All right. I'm going to adjourn the probable cause hearing. I'll adjourn it till after the holiday. So we'll do September 7th, 2023 at 9. All right. I canceled your bench warrant. Arrange for the place that you're taking tests to send the results to community corrections. And then in all other aspects, your bond will continue
Okay, thank
at
you.
a 10,000 personal recognizance bond. All right, with the previous conditions. Okay?
Okay, thank you.
Thank you.
Oh, man, I gotta get together.
Ordered to appear in court when ordered to do so.
Yes, yesterday.
Okay?
Oh, this guy's a situation. Where are we? We're in Lansing. That's where I got the infamous clip. This guy's something else.
All right, then.
Yes, he sure
Mr.
did.
Shively, the court is going to look at two factors here today. Are you a flight risk? Are you a danger to the public? The court looks at your criminal history, looks at your employment status, your ties to the community, as well as the allegations. You certainly are presumed innocent, sir. I wouldn't suggest anything otherwise, but I do have to make sure that the public is safe.
I mean, I might suggest it. You know, maybe it's not your role as a judge, but I'd suggest maybe. Maybe it's possible he's guilty. The prosecutor suggested it.
And that you do return to court on those posted court dates. You do have some criminal history.
Yeah, take a seat.
It looks like the last conviction you had, sir, was a
Sorry, Judge, I had to roll on the floor.
controlled substance conviction in November of 2018, felony retail fraud, first degree, guilty plea in 2021 of the 30th Circuit Court, and a couple of other property crimes prior to that. The court does recognize that this does carry an allegation of stalking. And again, I'm going to confirm that you are innocent until proven otherwise. So with that being said, I do find that a PR bond can be appropriate with conditions to ensure your appearance as well as the safety of Ms. Poyer. So the court's going to set a $750.
I love her.
Sir, you got to watch what you say because you're being recorded, first of all.
Okay, my bad.
It is a $750 personal recognizance bond with the following conditions, sir. First of all, you are not to possess, purchase, or consume any alcohol or controlled substances without a prescription. You are not to miss any court dates, and you are not to violate any state or local laws while you're on bond. Additionally, you must get permission from the court if you wish to leave the state of Michigan, and you're not allowed to possess or purchase any firearms, ammunition, or dangerous weapons. You also, sir, are not to have any contact with Jenna or Gina Poyer. That means
Well, that's
you
not gonna
cannot
happen.
call. Listen to me.
Stop it.
Okay.
All right. All right, Mr. Shively, I'm changing the bond here because if you tell me that you cannot abide by the court's conditions, that brings a concern to the court that you're going to appear and that she is safe. So it is a $7,500 10% bond, sir, with the following conditions again. I am also ordering a GPS tether to ensure that you do not go within 2,000 feet of where she lives,
Well played. Get the bond jacked up in a tether.
works, or goes to school. And I am ordering that victim notification be available to her if you do enter into that exclusion zone. So no contact, no assaultive
it's
behavior,
okay.
sir. That means absolutely no contact at all. You cannot call, write, page, email, text, no electronic communications of any kind. Can't have anybody else contact her on your behalf, and no threatening, harassing, or molesting behavior towards her or anyone else, and you may not go within 2,000 feet of where she's located at any time. That means from
Nice.
home, school, work, or if you see her in the grocery store, you turn around and go the other way. You absolutely can have no contact with her whatsoever. Do you understand that, Mr. Shively?
I do.
All right, anything else?
No, you have a good
Well, I don't
day.
have an attorney. All right, you too. Thank you, sir. You're
All right,
all set.
I
All right,
apologize.
thank you, officer.
I apologize for yelling, Your Honor. I did not mean that to come out as loud as it did.
Oh, well, I think it worked. I thought it was with Sutter. I thought you had actually left.
No, that was me. So I didn't mean to blow up everyone's eardrums. Apologies.
Okay, all right.
Thank you.
Yeah, stop talking about your case, please.
The court does call the case, People versus Orlando Austin.
Good morning, Your Honor. Nicole Hughes on behalf of the people.
Good morning.
This is Mr. Warren.
All right, we've got an update. It's short, but we've got a little update on the Planet Fitness shooter.
Good morning, Your Honor. I believe that there should have been a motion. No, I'm sorry. Actually, yes, there should have been a motion filed to have our.
Yes, to withdraw.
Yes.
Hi, Howard Brown asked about Julian's appointment, but not the.
Oh, okay. My understanding in our office was contacted by the MAC office, Mr. Brown, that I granted the public defender's motion to withdraw. The MAC office appointed Ms. Erica Julian, but she was not available today. And the court's understanding was that the public defender would be, because of that, asking for an adjournment on behalf of Mr. Austin.
Okay, no problem then, Your Honor. Your Honor, because of the conflict which was late discovered